Society in California. And I don't think we're going to be able to do this whole book because I read through it and I noticed it's going to take 2 more programs to finish this book. If you catch last week's program on YouTube, you'll see that I ended up with the problem is when the civil power says it's necessary for us to do thus and thus so, the question never arises to whether or not what civil power wants to do is lawful in the first place. Among law reformers, the current fad is to set up common law courts and justify doing this without the necessary prerequisites of first establishing a lawful civil authority or jural society by invoking the doctrine of necessity. This is pathetic because they justify setting up what are supposed to be lawful courts and with an unlawful doctrine because the maxims of law is necessary. Necessity knows no law. Now we get to the part of emergency powers. Emergency powers, as stated above, necessity gave birth to the emergency powers idea that encompasses all of those forms of power such as martial law, martial rule, and more benign form of martial law, a more benign form, national emergencies, and so on. When nations stoop to impose such powers on its people, they are but one step away from revolution and chaos. The only forms of law used are international and municipal law that have never in the history of the world formed the basis of a sound and long-lasting system of law. This problem is such law is not governed by any standard, as will be made clearer below. Thus, its nature consistently changes with the whims of the current commander-in-chief. It frustrates, confuses, and angers the populace that must live under such governments. And eventually, the people rise up to overthrow such powers, either by concerted refusal to go along or to get along, or by a bloodbath, as in France in the revolutions beginning in 1790, which did not cease to occur until well into the mid-1800s. More evidence for the potential self-destruction of such governments is seen in the fact that such governments only operate under democracies, not republics. That's why everybody's talking about the democracies today, because of that's the evil government. Because ours was a republic democracy, remember? The Christian nation that survived and prospered from the beginning. This is done to maintain the fiction that a lawful civil authority still exists. But democracies only stay in power as long as they can maintain a welfare state of benefits, privileges, and opportunities. So these evil people are using this democracy to cover up what they're doing. By definition, martial law and emergency powers exist in the second place because lawful civil authority, process, and procedure have ceased to exist in the normal course of things. We're going to read about that happening with Lincoln. Martial law, which is built upon no settled principles but is entirely arbitrary in its decisions, is in truth and reality no law, but something indulged rather than allowed as law. The necessity of order and discipline in the army is the only thing which can give its countenance, and therefore it ought not to be permitted in time of peace. When king's courts are open for all persons to receive justice according to the laws of the land. Further, martial law is neither more nor less than the will of the general who commands the army. It overrides and suppresses all existing civil laws, civil officers, and civil authorities by the arbitrary excuse of military power. When you're in the Marine Corps, you do your push-ups, boy. You don't slough off. How then does martial law affect the administration of law and the courts? In the state of California versus O.J. Simpson, those who saw the early part of the case may remember the confusion in arraigning him. A flag without Goldfinch stood in the court as he was arraigned under local common law. There was no maritime flag, no military parade flag in the court, just a regular American flag of the Republic. And under common law, the Christian common law, okay? And they arraigned O.J. Simpson that way. O.J. Simpson was arraigned under common law. But confusion arose because Simpson did not understand what the court wanted when it requested his name. Proceedings restarted and he identified himself properly. You know, he was a football player. After arraignment, a new judge was assigned, Ito, and a new flag was placed in the court with a gold fringe around its edge. This is because the law of territory occupied as an incident of war or belligerency whenever the local civil authority is superseded in whole or part by the military authority of the occupying power. We were under maritime, so they includes local criminal law as adopted or modified by competent authority, and the proclamations, ordinances, regulations, or orders promulgated by competent authority of the occupying power, the maritime military power. Basically, the court under law of the territory arraigned Simpson under common law with one flag, but tried him under a military flag. Is this possible? Congress has stated, a majority of the people of the United States have lived all of their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. The problem of how a constitutional democracy reacts to great crises, however, far antedates the Great Depression. As a philosophical issue, its origins reach back to the Greek city-states and the Roman Republic. And in the United States, actions taken by the government in time of great crisis have, at least the Civil War, in important ways shaped the present phenomenon of a permanent state of national emergency. I remember, I forget his name now, I did a program on the War and Emergency Powers, Eugene Schroeder. You might be able to find that on YouTube if you look up War and Emergency Powers with Eugene Schroeder. It's about an hour long. National emergencies are a state of national crisis, a situation demanding immediate and extraordinary national or federal action. Congress has made little or no distinction between a state of a national emergency and a state of war. They don't make any differentiation, but Congress, we find, is unlawful since Lincoln. Publicists tell us that America is the greatest nation in the world and the longest lasting form of constitutional government in the history of the world. In fact, the constitutional republic lasted from 1787 to 1861, less than 75 years. 75 years we had a Christian nation, folks. The death of the republic, as shown above, was engineered by Abraham Lincoln. Note, Lincoln did not declare war on the South because he had not the power. This is so because Congress, who had the power to declare war, could not conduct business without a quorum, which was lost when 7 southern states walked out 6 months before. Why did they walk out? The North was doing all the business and using the states, oppressing them, taking their goods and bringing them to the manufacturing plants up north, right? And controlling the price. There was a formal declaration of the end of the hostilities, but there was never a formal act to end martial law. So the end of the Civil War never happened. The end of the martial law by the commander-in-chief, the president after Lincoln's assassination, never happened. FDR created emergency powers and developed them to their highest form of expression in the history of the country. During World War II. All this while Congress was in recess on March 6, 1933, under the guise of a banking crisis. By executive order, FDR, Franklin Delano Roosevelt, altered one word in the Trading with the Enemy Act, which made the American people living in the States enemies of the United States and subjected them for revenue purposes to licensure in all commercial activities. Instead of this act, originally passing during World War I, applying only to persons doing business with the enemy without the United States, it was changed to read within the United States. An extension of this idea is seen where the present law forbids members of banks of the Federal Reserve System to transact banking business except under regulations of the Secretary of the Treasury during an emergency proclaimed by the President, 12 U.S.C. Congress returned from recess and rubber-stamped Roosevelt's executive orders and in less than 2 years, all the states passed similar statutes because 12 U.S.C. every president reaffirms the state of national emergency annually. So today, is Trump continuing the emergency? That's a question. You probably know the answer. The answer to the question above, are we living under martial law, etc., by now must be an emphatic yes. We are living under martial law. We have been since the Civil War, but they don't tell you this. Where is Congress in the scheme of things? What sort of power does it have? In the U.S. codes, we find that the Congress is not a body that sits according to law or positive act, but by resolution. The word resolution means the term is usually employed in adoption of a motion, the subject matter of which would not properly constitute a statute, such as the mere expression of opinion, an alteration of the rules, a vote of thanks, or a censure, etc. Such is not law, but merely a form in which a legislative body expresses an opinion. Smoke of law. And the chief distinction between a resolution and a law is that the former is used whenever the legislative body passing it wishes merely to express an opinion as to some given matter or thing, and is only to have a temporary effect on such particular thing, while by a law it is intended to permanently direct and control matters applying to persons or things in general. To this day, a president pays lip service to Congress with declarations of war. Now we know why there is always such a public display at each time the president and Congress come into conflict when such situations arise. The Korean War, the Vietnam War, Grenada, Desert Storm, etc. In fact, the president as commander-in-chief with emergency powers never needs the approval of Congress or anyone else to engage in peace actions or war. Thus, today, Congress makes only public policy such acts are officially public law, but they have no real substance in law. Public law is really private law, which is the principles under which the freedom of contract or private dealings is restricted by law for the good of the community. Now, for those who moan, roll their eyes, and beat their breasts each time Christians speak of God's law and claim that any law based on God's law would impose morality on the people, consider that the term policy as applied to a statute, regulation, rule of law, course of action, or the like refers to its probable effect, tendency, or object, considered with reference to the social or political well-being of the state. Thus, certain classes of acts are said to be against public policy when the law refuses to enforce or recognize them on the ground that they have mischievous tendency so as to be injurious to the interest of the state apart from illegality or immorality. So legality and morality have nothing to do with public policy. When you're under maritime martial law, we just don't want to injure the interest of the state. In other words, whether it's legal or moral does not matter, so long as the interests of the state are advanced. If this is not a statement of morality, then the English language has no meaning further. Public policy is a variable quantity. It must and does vary, and the habits, capabilities, capacities, and opportunities of the public. Whatever Lola wants, Lola gets. A glitch comes to mind here, something like, what is moral depends on whose ox is gored, who's wounded, yeah? Martial law principles. As they relate to the institution and execution of martial law, its principles are as follows. First, that no government worthy of the name will permit itself to be overturned, the object for which it was instituted to be defeated by the turbulent element in its midst, simply because the civil administration fails, whether culpable or otherwise, to perform the function prescribed by the written law, but in such case it is the right and duty of government in self-defense to resort to a higher and unwritten law to meet the exigency or the emergency. Second, the force called into active operation in this exigency is of necessity the military and martial law, its rule of conduct. Third, the martial law thus may be invoked either by executive or law-making power, although the former generally will be the case. Fourth, a proclamation establishing martial law, while convenient as notifying to all the true conditions, is not necessary, but the placing the military in control by proper authority carries its own proclamation that martial law there prevails. In other words, it's not always told to the people that they put down their Christian law and set up martial law. Fifth, in the exercise of this power, the military may utilize, if convenient to all authorities, the civil administration, but this to the extent only that the military may deem such course desirable. Sixth, in the enforcement of martial law, the military may not wanton with power and use it tyrannically or for the oppression of the community. And should this be done, the perpetrators, after law has resumed its proper sway, may be brought before the civil courts, where such acts may be inquired into. The question for the court to determine in such case being how the heart stood when such alleged unlawful acts were perpetrated. Unmoral acts. The gold-fringed flag. The law reform is always saying that the gold-fringed flag that hangs in the courts of this land is an admiralty flag. This is more mythology. The truth is, admiralty is limited only to certain kinds of actions, none of which are dealt with in the most of our courts today. This ought to give someone a clue. But just what does such a flag signify? Is the fringe just decoration? Where does the gold-fringed flag come from? In 1959, President Dwight David Eisenhower, by executive order and in the Federal Register and pursuant to law, stated that a military flag is a flag that resembles the regular flag of the United States, except that it has a yellow fringe border on 3 sides. The President designates this deviation from regular flags by executive order and in his capacity as Commander-in-Chief. Thus, the fringe is strictly within the discretion of the President as Commander-in-Chief of the Army and Navy, and gave him power over the courts too. The continued use of such fringe is prescribed in current Army regulations. Ancient custom sanctions the use of fringe on regimental colors and standards, but there seems to be no good reason or precedent for its use on other flags. According to Army regulations, the flag is trimmed on 3 sides with fringe of gold, 2.5 inches wide, and that such flags are flown indoors only in military courtrooms. And further, the gold fringe flag is not to be carried by anyone except units of the United States Army and the United States Army Divisions Associations. I remember when I was in Columbia Heights in the courtroom there, and I asked the judge, am I in the maritime jurisdiction when I come up to you, past the bar, or am I in the common law jurisdiction? He said the maritime jurisdiction, which is the military jurisdiction. That's why they're saying it's not just maritime, it's military. So that was a military code back in the 80s in Columbia Heights in Oka County. Why does this flag fly in all federal, state, and county and city if they are not military courts? Why does the U.S. flag fly over or above all state flags? This never happened before 1861. They didn't fly the U.S. flag above all these other flags. Does this specific year ring a bell with anyone? 1861? The truth is the gold-fringed flag flies in military courts that sit in summary court-martial proceedings against civilians, and such courts are governed in part by local rules, but more especially by the Manual of Courts Martial. So you didn't know you're going to a courts martial and you're going to the courts today. That's what they are. What is an enemy? To clarify whether or not the people are the enemy of the United States subject to military courts, one need only acquire the Manual for Courts Martial and look up the word enemy. Enemy includes organized forces of the enemy in time of war, any hostile body that our forces may be opposing, such as rebellious mob, a band of renegades, and includes civilians as well as members of military organizations. Enemy is not restricted to the enemy government or its armed forces. All the citizens of one belligerent are the enemies of the government and all the citizens of the other. Organized forces not only includes the regular military, but the National Guard, all state, all county, and city law enforcement officers under the National Guard. In effect, this means we are being held arbitrage, open and notoriously by our own neighbors, friends, and loved ones. Last, concerning what constitutes a time of war, it exists for purposes of RCM and parts 4 and 5 of this manual. What is RCM? I don't know. Well, you probably can understand it out there, some of you. In virtually every act conceivable by any person against which the United States government has made a law, rule, or regulation, the details of the crimes that civilians can commit that are classed as acts of war cover 125 pages in the manual for courts martial. Citizens, neutral, sovereign citizen, state citizen, or foreign national. There has been considerable noise among law reformers concerning one's status, whether one is a citizen, neutral, or some other. One idea is one defends himself by being a state citizen. Now the status of a state citizen depends on what state he is a citizen of. The problem is who is governor, attorney general, secretary of state, and who represents the state citizen. To claim state citizenship when the officers of that state do not exist is not just bogus argument, but ludicrous as well. So to be on the land national, there's without a proper form of government, because that government was put down by Lincoln during the beginning of the Civil War. The same is true for common law citizens. There is nothing in law that even routinely defines common law citizen. The reason why is common law is a body of law, process, procedure, rights, privileges, immunities, courts, and duties common to all men by virtue of their Christian status. Christian status. It applies no rules to create a state. One would think that this should be an absolute prerequisite for the existence of common law citizens. Without a state of some kind that protects one's rights, there are no citizens of the common law variety of any other. Black says a citizen in general law is a member of a free city or jural society, possessing all the rights and privileges which can be enjoyed by any person under its constitution and government, and subject to the corresponding duties. And in an American law, one who under the Constitution and the laws of the United States or of a particular state, and by virtue of birth or naturalization within the jurisdiction, is a member of the political community owing allegiance and being entitled to the enjoyment of full civil rights. One can claim to have revoked, rescinded, or abolished all the applications for benefits, privileges, immunities, or opportunities in commerce, in maritime, or in martial law that he has entered into in the past, or tried to abolish his signatures on such documents, but there is no authority in such instruments to compel the martial law governments to comply. Besides, a subject does not compel the performance of the master. They are the martial government, martial law, we are the subjects. A neutral at first sight is one who appears disinterested to the standing of the belligerents in a war. Like Sweden during World War II, remember? Citizens of neutral states resident in or visiting invaded or occupied territory can claim no immunity from the customary laws of war related to the communications with an enemy. Any form of intercourse with the enemy is communications with the enemy. Taking the stance of a neutral will not help you get there from here. There are also those who claim to be sovereign citizens in America's law. There is no such thing because the only sovereign is the people. In a collective sense, who are cloaked with sovereignty under God. The only real sovereign and the people are only cloaked with sovereignty while they act in accordance with God's law. Those who act in commerce have no sovereignty because they are acting with lex mercatoria, the law of the merchant. Lex mercatoria is also the domain of the god of Mercury, the god of the traders and thieves. Are these sovereign citizens godly people or pretenders to a jurisdiction that does not exist? A foreign national is all persons whether or not subject to military law, except the military judge, members, and foreign nationals outside the territorial limits of the United States, who are not subject to the code. Territorial jurisdiction is considered as limited to cases arising or persons residing within the defined territory, as a judicial district, etc. The authority of any court is limited by the boundaries thus fixed. A territory is also a part of a country, separated from the rest, and subject to a particular jurisdiction. The term United States has many meanings. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns, the family of nations. It may designate territory over which sovereignty of the United States extends, or it may be a collective name of the states which are united by and under the Constitution, the Christian Constitution. The United States is defined in Title 26, the IRS Code, as the District of Columbia, Guam, Puerto Rico, Virgin Islands, Northern Marianas, and the American Samoa. Foreign nationals are unique and may live under a separate law system within the geographical limits of martial law powers. The most well-known example of this is the Amish Christian sect. This ought to give someone a clue. The bottom line is the only man or woman outside martial law, jurisdiction, and courts is the Christian. When acting in the mode and character of a Christian, the problem today is most Christians are engaged in commerce and thus void of all their rights, privileges, and immunities under God and accepted instead of the benefices of Mercury, and this places them under martial law. In short, we have sold our birthright for a mess of pottage. I think the Amish pay Social Security, I think, or something. They pay something, but they stay away from everything else. Person, human being, natural person, natural man. Person is an indispensable word with varied overlapping meanings, often used without definition, as in the United States Constitution, Articles 1, 2, 3, and 4, Amendments 5, 6, 7, 4, 5, 7, 8, 14, and 12. Oh, wait. Defined and redefined in an endless succession of special purpose statutes with no assurance to the profession that this is the person you thought you were talking about. It's a loose term, person. The definitions here give an overview of the current usage. Person is defined as human being, and not as person is defined as human being, not a human being, not a singular. It can mean one who holds a morality common to human beings, an individual or a natural person. It also means artificial person, which covers all forms of corporations or incorporation, profit or non-profit, and is being distinct from its shareholders. Thus, a church corporation 501c3 is a person, but an unincorporated church or an association is not a person unless expressly declared by statute. One may say that Christian church has always had the right to be a corpora, but this is truly only if the church has not sought privileges from governments. In such case, a church exchanges its rights for privileges. Corpora, C-O-R-P-O-R-E, corpora, does not apply to state-authorized corporations anywhere in law. One definition of a human being is a monster, a human being by birth, but in some part resembled a lower animal. Blackstone says a monster is one who hath no inheritable blood and cannot be heir to any land, albeit be brought forth in marriage. But although it hath deformity in any part of its body, yet if it hath human shape, it may be heir. Elsewhere, a human being is mundane, secular, and so what do Christians have to do with such ideas? And why do so many Christians consider themselves human beings? Is not this a contradiction in terms? The Apostle Paul in the last word of the natural man, but the natural man receiveth not the things of the Spirit of God, for they are foolishness unto him. Neither can he know them, because they are spiritually discerned. But he that is spiritual judges all things, yet he himself is judge of no man. For who hath known the mind of Yahweh, that he may instruct him? But we have the mind of Messiah. The point is, persons and all its related entities are subject to codes, ordinances, rules, etc. of the U.S., the states, counties, cities. Read the codes and see for yourself. They only speak of persons. The rules of English grammar, since martial powers cannot use lawful civil authority, process, and procedure, they must use Christian procedures, see, some of the language in which to write statutes, codes, ordinances, rules, etc. Some form of language they need, right? Accumulations, simplifications, systematic treatments of statute are called codes. The Code of Federal Regulations is not a code of laws, but an annually updated collection of the regulations enacted by executive regulatory agencies without the authority of Congress. In other words, smoking law, law of the name of law, it's just regulations, military regulations. Emergency power codes are within their hodgepodge of words, phrases, meanings, convolutions, etc., are a code of hidden meanings that is never interpreted consistently by any branch of the government, much less by bureaucrats. Capitalization and abbreviations of words and names of persons is a devious thing in these codes, and in the process which flows from them. Thus, when a court issues judgment against a defendant, the order is always typed in all capital letters as follows. It is so ordered, which in the rules of English grammar has no meaning at all. They worship nothing. It's a satanic worship service procedure in the court. A name typed in all capital letters on driver's license, social security cards, court documents, process, and credit cards is called a nom de guerre, literally a name of war. But it's on the tombstones also. Thus, under international law, all parties to a case must appear by the nom de guerre, because an alien enemy cannot maintain an action during the war in its own name. You got to have the war name. When you're a military, in the Marine Corps, you have a number. Every man in the military has a number. If the Christian name be wholly mistaken, this is regularly fatal to all legal instruments, as well as declarations and pleadings as grants and obligations. And the reason is because it is repugnant to the rules of Christian religion that there should be a Christian without a name of baptism, or that such persons should have two Christian names, since our church allows of no rebaptizing. And therefore, if a person enters into a bond by a wrong Christian name, he cannot be declared against by the name in the obligation, and his true name brought in an alias, for that supposes the possibility of two Christian names. And you cannot declare against the party by his right name, and ever made the deed by his wrong name. For this is to set up an argument, an averment contrary to the deed. And there is this sanction allowed to every solemn contract, that it cannot be opposed but by a thing of equal validity. And if he be impleaded by the name of the deed, he may plead that he is another person, and that it is not his deed. The same is true for parts of names abbreviated, where an initial is no name at all. An initial cannot be regarded as a Christian name, and we are of opinion that the word misnomer, which means a naming amiss, is wide enough to cover the faulty indication of a Christian name by means of an initial. Concerning misnomer, it is a good plea in abatement, for since names are the only marks and indicia which humankind can understand each other by, if the name be omitted or mistaken, it is compliant against nobody. We need to have full Christian names to our neighbors in Christianity. One reason why all emergency powers courts have no lawful process is because they never use a lawful Christian name, spelled according to the rules of English grammar, as a proper noun, but one must assert the error in the name as soon as one receives any process from such governments, or one can never raise the question again. Especially is this seen in the heading of martial law process, whose courts are forbidden to use any process contrary to international law under which they sit. If used, it is fatal to their process when properly exposed. At the outset of any process issued by such courts or their agents. It is interesting to note that an IRS scheme in forms and letters to alleged taxpayers, one name is always abbreviated in all letters. They request only a middle initial, not a full name. Often when the nom de guerre issue is raised against them, they change a nom de guerre to some form of abbreviated name, and thereby seek to give the impression as reasonable men who only want to comply with law. They want to follow their martial military law. They want you to be sucked into it. Affidavits, because that's their process, that's what they need to do. Affidavits in all caps have no meaning, verified complaints, and are repugnant to the laws of English grammar. They have no real force and effect in traffic warrants, notices of warrants, notices of liens, and levies, and so on, and so on, and so on, unless one has already granted jurisdiction. Their purpose is to seduce the unwary into voluntary compliance. And in the military, you get in here, you're part of the military. You have to be in the army. You have to pay certain dues. You have to go through boot camp. You have to do certain things. Military is military. They don't have no morality. They have a necessity, emergency need to do things. But there's people within those confines that are using that as extortioners, and Satan is behind much of it. One may see words in martial law process like, you must appear, blah, blah, blah. It appears to demand a personal appearance, but in law, must means may. What's really being said is, we invite you to appear for the benefit of discussion. Only the word shall compels performance. Other deceptive phrases are notice of, means an invitation to, notice to appear, notice of levy, notice to remove, notice of warrant, notice of trespass, order to show cause, order and demand, and many others are simply deceptive word games. Commonly, emergency powers agents that send letters to people threatening or implying all sorts of things. But the letter, no matter who sends it, has no force or effect in law unless you voluntarily default with an improper response. Most people write a letter back not realizing the agent who sent the letter now knows you have no idea what the law is, because you answered a letter with a letter, not a lawful process. When people are robbing our country of the Christian jurisdiction, they're in the territory of Satan. They have no standing, because Yeshua already defeated the devil, right? Failing to answer letters with lawful process in common law subjects one to martial law process, and the case will result with default. This is true of all communications from such powers or agent. By the way, a IRS has no lawful authority to send letters to anyone in the 50 states who is not actively engaged in a trade or business with the federal government, the federal corporation known as the United States. There was many different United States that they made. Okay, we're getting close to the end. We're at the de facto, de jure Republican forms of civil governments. I can go into that for the last program I've got. I think I'd like to read the last 2 pages, because that'll bring us up to date now on some stuff here. I got some other stuff I could read besides, but let's read the last 2 pages here. We'll catch up later. I'll mark that I read this to the next book, and we'll fit the rest of the book there. Fill in the rest of the book. Thank you for listening, and thank you for being patient, having a good ear to take notes if you need to. Domestically, Lincoln used deception to save the Union. This is evident from the record. If the Union were saved intact, Reconstruction was a nullity, because the states were intact. If, however, the Union was destroyed, Reconstruction was necessary for erecting a new Union in the image and likeness of its speculating creator, Mercury, under the imposed military power of the commander-in-chief, dedicated to the proposition that public slavery, and by destroying Christianity in the states for enhancing the expanding commerce, is a better idea. France was happy when they made the government. That's why they gave us the Statue of Liberty, meaning liberty without God. We need to get rid of that statue if we want to bring our Christian nation back. It is no secret that the criminally infamous Secretary of Treasury, Solomon P. Chase, in 1861, through his factotum Coke, boasted that the initial bonds issued to fund the Lincoln versus all states war were a first mortgage upon all property of the United States. It is also it was a first mortgage too. It is also no secret that the interest on these bonds was not paid as late as 1953. This is the same Chief Justice Chase, by the way, who created and established by his own judicial decree the huge tax base to pay his filthy war bonds sold to the Bank of England. The Chase Bank, remember? Contained in the purported 14th Amendment, this is why the public debt cannot be questioned. Could this have been a conflict of interest? It is no secret. Harmless commerce is dangerous. Principis obsta, oppose the first appearance of evil. Nip the shoots of the arbitrary power in the bud, is the only maxim which can ever preserve the liberties of any people. When the people give way, their deceivers, betrayers, and destroyers press upon them so fast that there is no resisting afterwards. The nature of the encroachment upon the American Constitution is such as to grow every day more and more encroaching. Like a cancer, it eats faster and faster every hour. The revenue creates pensioners, and the pensioners urge for more revenue. The people grow less steady, spirited, and virtuous. The seekers more numerous and more corrupt. And every day increases the circles of their dependence and expectants until virtue, integrity, public spirit, simplicity, and frugality become objects of ridicule and scorn. And vanity, luxury, foppery, selfishness, meanness, and downright venality swallow up the whole society. For resistance to law, every government has ample powers to punish offenders. For usurpation, governments provided no adequate remedy. They can punish you for resisting any of their military laws, but to punish those upsurging the governments, they have no remedy. But we have to do it ourselves, with God's help. What hath commerce wrought? The destruction of a confederacy of Christian states. Final thoughts. If we look about the land today where there appears to be nothing to justify the maintenance of a permanent state of national emergency by the United States government. There isn't a war going on. We aren't in a major economic collapse, yet the Cold War appears to have thawed. The question is, why a permanent state of national emergency? The answer comes down to something quite simple and actually can be summarized in one word: hooked, aka addicted. They're hooked on robbing us. In earlier versions of this work, we summarize things by asking a good many questions and providing a simple yet unsatisfying solution. Subsequent research based on a theory of the case that developed out of earlier versions of this work now shows a clearer and more concise answer. Briefly, it comes down to the following. At least 7 years before Lincoln's War, a number of states began to adjourn their state legislatures sine die, without a day. This discovery makes no sense until we realize that the United States senators of these northern states, appointed at that time by state legislatures, were the most radical proponents of policies that would drive the South out of the Union. If successful, this would have eliminated 11 out of 37 states, and only 26 would be left: Missouri and 3 other states. One may have been California, where they were contemplating an exodus too, also. So not to join the South. If these 4 states leave, we are down to 22 states left in the Union. Since it only takes 2/3 majority, 25 of the states, to succeed and terminate the federal constitution, any combination of 10 states by sine die adjournment ends the Union. For all intents and purposes, there would be no United States of America, only a collection of independent countries on the North American continent. But why would the states want to terminate the Constitution? The answer is the Christian underpinnings and presuppositions embodied in the Constitution put too many restrictions on development of commerce between the states. With the Constitution gone, it was survival of the fittest. And with the money power held by the northern banks, it is likely that much of the southern raw material production would have ended up in the hands of the northern industrialists at the price that the North wanted to pay for it. The South would have been reduced to feudal states under control of the northern commercial interests, and slavery would have probably still existed as a matter of sheer economic necessity. Then along came Abe with a better idea. Lincoln's ego could not agree with the idea of the United States being broken up, especially on his watch. He also knew the smell of the winds blowing out of the north and turned it to his advantage. His problem was how to keep the Union together, at least while he was president, and still satisfy the demands of the northern industrialists, commercial interests, and bankers. Remember, at this time in our nation's history, the country was literally busting out of the seams with western expansion, discovery of gold in California, development of steam plants and engines, invention, and so on. Everyone was scrambling to get his piece of the pie, and with the Christian consensus greatly reduced, there was no one to sound the alarm from the pulpit. We can now see that Lincoln's plan to put the nation under military law and resurrect the old Roman law with its heavy emphasis on commerce satisfied all competing interests, except those of the South and the common people of America. More importantly, it got rid of the Constitution and served notice on a Christian world that the United States was no longer a Christian nation. To show its gratitude to the United States for what it had done in rejecting Christianity, France produced a monument to its own French Enlightenment view of law and liberty. Today, this monument stands just off the coast of New York, on an island all its own. This monument may be called the Statue of Liberty, but it is in fact a celebration of lawlessness and licentiousness. The Greek and Roman character of the statue is lost only on the ignorant. Let me read that one more time. To show its gratitude to the United States for what it had done in rejecting Christianity, France, which kicked out all Christians when they did the guillotine thing, found out it was bad for their country, so they brought it back in. France produced a monument to its own French Enlightenment view of law and liberty. Today, this monument stands just off the coast of New York on an island all its own. The monument may be called the Statue of Liberty, but it is in fact a celebration of lawlessness and licentiousness. The Greek and Roman character of the statue is lost only on the ignorant. That the elimination of the restrictions of God's law was in the mind of all is clear. The assault on Christianity in politics and civil government that was begun by Lincoln in the massive bloodletting of Lincoln's War was simply carried to its logical conclusion by Roosevelt. Today, the United States government is the unenviable position of being between a rock and a hard place. Its people demand bread and circuses. Its politicians are little more than dilettantes, a hard place. Major industrial powers upon whom the tax system is based are leaving the land. The lawyers and the taxmen suck the substance from the people's lives and subvert their liberties daily. The bureaucrats cannot even get paid. And throughout the land there is a wailing and gnashing of teeth as the pain level rises. And all this because the people in America gave up the God that gave them life, liberty, and property, and exchanged him for the gods of Mars and Mercury so they could engage in commerce, and everyone would then have the privilege of engaging legalized theft that brings profit only to the rich. We have all become hooked on commerce and the easy life and have even redefined what is left of Christianity to justify it. After all, even our churches sit in commerce as 501c3 corporate, which they should never do. They don't need to do that. And so this is the stepping stone for Satan if we don't turn it around. So we pray in the name of Yeshua that we turn this around and that people will wake up everywhere. Either the people will turn back to God who gave them life and obey his laws, or they will be ground to dust, mixed with their own blood on their own land. Thus, because they're going to get worse and worse. The deceivers are going to get worse and worse, folks. We need to nip it in the bud, or we're going to end up with tyranny in this land. And my people which are called by my name shall humble themselves. Are you called by his name, Yeshua, his name, Jesus? That's not his name. That was added by the people that wanted to destroy the name of Yeshua and destroy our coming together in that name. You got to understand that, folks, and don't be offended in Yeshua, okay? Thus, if my people which are called by my name, the hallelujah name Yeshua, Yahushua, shall humble themselves and pray and seek my face and turn from their wicked ways, then will I hear from heaven, will forgive their sins, and I will heal their land. You can't get this martial law out of here unless God helps us heal the land. We need God to heal America today. We need God in America again today. We need Yahovah, not the term God. The term God is, we need Eloi. That's how you say his. God is a misnomer also. But if you turn away and forsake but people know it as who he is. Let it be with understanding for those that know that, but we know to make the crooked thing straight, amen? But if you turn away and forsake my statutes and my commandments which I have set before you, you shall go and serve other gods and worship them, and then will I pluck them up by the roots out of my land, which I have given them, and this house which I have sanctified for my name will I cast out of my sight, and will make it a proverb and a byword among all nations. Please note, God is not speaking here to the other guys, the non-believers, but to you and me, today, now, and forever. Even so come, Yeshua Messiah. Amen. That is the end of that, but we have a portion to read on the next program. We got a little time left. Let's get into this one here. This is quite a read here. Probably not going to do it all, but we'll do part of it. This is a must-read, very important. It even confirms that Minnesota Senator Paul Wellstone and his wife and daughter were murdered, and why. This change began in the mid-1970s when the Federal Land Bank illegally foreclosed on farmers' mortgages all throughout the Midwest. In each of these cases, the farmers were defrauded by the banks with the approval of the Federal Reserve System. These court cases would eventually become known as the Farmer Claims Program. In 1978, an elderly French farmer in Colorado purchased a farm with a loan from the Federal Land Bank. After he died, the property was passed to his son, Roy Schwasinger, Jr. You can look that up on the internet. Roy Schwasinger, Schwasinger, Jr., who was a retired military general. You can look up General Vallely too. Stand Up America Now. No, Stand Up America, it's something else. He's in Montana, General Vallely. Retired General Vallely, trying to help bring back America to the original Christian Constitution. Who was retired military general soon after the Federal Land Bank officer and federal marshal appeared on his property and informed him that the bank was foreclosing on his farm and to vacate within 30 days. Without his knowledge, his deceased father signed a stipulation which reverted the property back to the Federal Land Bank in the event of the borrower's death. Outraged Roy Schwasinger filed a class action lawsuit in the Denver federal court system. Okay, you can look that up on the internet if you want. I'm going to go over to Puerto Rican Trust Federal Reserve. We got the Federal Reserve Act of 1913. All present and exceeding debts against the U.S. Treasury must be assumed by the Federal Reserve. Executive Order 12778, Principles of Ethic Conduct for Government Officers and Employees. And I think Bush signed that, H.W. Bush. He had to because that lawsuit came up to him at his time. And it says here that they were required to go back to the common law instead of an admiralty law under the Goldfinch Flags under common law. If there was no damage or harm done to then there is no violation of the law. This would eliminate millions of laws which are used to control the masses and protect corrupt politicians. Lastly, the IRS would have to be dismantled and replaced with a national sales tax. This is the basis of NESARA, N-E-S-A-R-A law, which when the legal team finally settled on a figure, each individual would receive $20 million payout per claim, multiplied by a total of 336,000 claims that were filed against the U.S. federal government. A total payout would come to a staggering $6.6 trillion. And later on, we see that they were going to do these things, but we had the 9/11, right? And there were offices that were working on these things in the buildings of 9/11. We've only got a couple minutes left. When the Minnesota Senator Paul Wilson was about to break the gag order, but before he could, his small passenger plane crashed, killing his wife, daughter, and himself. If fear isn't enough to keep Congress in line, money is. The CIA routinely bribes senators with stolen loot from the bankable programs. Every senator has been bribed with a minimum of $200 million deposited in the Bank of America account in Canada. You will never hear the media networks report about NESARA. To maintain silence, the major news networks such as CNN are paid in the tune of $2 billion annually. So, when they bombed 9/11, guess what? This process of changing the IRS and the Federal Reserve back to the Christian Constitution was stopped. They were starting to do that already in America. And it's in the making still, folks. So hang in there and do your bit as a Christian, and we are going to come to the time when the sons of God will possess the kingdom, like the Bible says in the book of Daniel. But before that, we're under siege, under robbery, robbing, killing. They will under captivity, which is siege, many days. But then the time came when the saints possessed the kingdom. We're getting ready for that, folks. That's why all this teaching. I hope you learned something when you listen to this. If you are just tuning in now to listen to it on YouTube, you can go back and listen to it and take notes. And I don't ring any bells or anything. I just went straight through quoting it. I hope some of you have the temperance to be able to do that, and understand. Or you can look this up if it's on the internet somewhere. Introduction to the Christian Juror Society in California. That's what we've been reading from the last two programs. So do I sign off now? Time is up. We'll see you next week at the same time. And you can go back in my history, and some of the sound isn't so good on some of the programs. Hopefully we're getting better in the future here. And Yeshua help every one of you out there that are in trouble. Remember, He's a God that He knows about our own troubles. He's not far away from our troubles. He is a God of compassion. He knows our infirmities, and He will help you. And health is the children's bread. Read it in the book of Proverbs. Study the book of Proverbs. Be health to all your flesh. In the name of Yeshua, I pray. If you have a problem, you believe God for it, and He'll heal you. And become one of the children by Acts 2:38. Join the body of Messiah. Hallelujah, hallelujah. Amen and amen. The King of Glory is coming soon in clouds of power and great glory, taking vengeance on them that know not God and obey not the gospel of Yeshua the Messiah. He's coming soon. Amen. Off the air we go.